figure out something.
Hi,
that
everybody.
makes big companies.
I'm going to get us started
on the
now.
hook legally somehow.
Welcome to George Washington
Somewhere.
University. My name is Susan Aronson. I'm a professor here at the Institute of International Economic Policy. Welcome to GW. We're very glad to see you here, and I know I need not remind you that we're here the day after a terrorist event. Life goes on, but for many people, thank you, Paul, life doesn't go on. Life is forever changed. As you know, many internet companies such as Google, WeChat, Twitter have special responsibilities in a time of terrorism, and they have a difficult balance to achieve. On one hand, they're supposed to facilitate the exchange of ideas, but on the other hand, they must constantly monitor their platforms, and at times they must censor speech. And in the past, that job has been the job of governments, not business. So we've put together a fantastic panel to examine how firms can achieve this difficult balance. I'd like to thank our partner, Software and Information Industries Association, and our other partner, the Internet Society of Greater Washington, D.C., for webcasting today's event. And I'd also like to thank Kyle Renner and his excellent staff for facilitating today's event. So now I'd like to introduce Mark MacCarthy of SIIA, who will moderate. Mark?
Okay. Thank you, Susan. And thank you all for coming in, and for those of you online who are watching the streamed version of this event. We meet, as Susan mentioned, at a sad time. The world is mourning the loss of life from the attacks in Brussels. Coming after the attacks in Paris and San Bernardino and Istanbul, we're clearly at a critical juncture in the struggle against violent extremism. And so that makes today's topic tragically timely and relevant. As Susan mentioned, we've got a pretty good panel for you today for this conversation. I'm going to start with a few remarks and then turn to them for a conversation, and we'll have plenty of time for your questions. So what the title of the event is, what are the responsibilities of tech companies in an age of international terrorism? So what are they? I'd say three. They have takedown responsibilities, but they have countervailing responsibilities to promote free speech and association. And lastly, they have affirmative responsibilities to take steps to counter violent extremism. Now, let me be clear. None of these responsibilities is legal, at least under U.S. law. Section 230 of the Communications Decency Act is crystal clear. Internet platforms are not publishers of the content that is provided on their systems by third parties. This legal principle has allowed internet platforms to flourish and to grow, making them platforms for free speech, innovation, economic growth, and so on. And we don't want to do anything that would suggest that they should not have that kind of protection from liability. But that lack of legal liability doesn't mean that they have no social responsibilities. After all, Section 230 was put in place as the Good Samaritan provision. It was designed to allow internet intermediaries to take action against problematic content on their systems without thereby having to assume the full legal and financial liability for having the stuff there in the first place. Now, the last decade has seen the rise and the public acceptance of the socially responsible internet intermediary. Think of all the different online companies, the social networks, the online payment systems, the search engines, the marketplaces, the web hosting companies, the ISPs. They all have policies and procedures in place reasonably designed to prevent their systems from being used by harmful conduct or speech. And it works best because each of these companies has the flexibility to design their own policies and procedures suitable for their view of what the public interest is and what's appropriate for their users. Now, we've seen these internal policies at work in the case of ISIS. Facebook has zero tolerance for ISIS. Twitter has a similar rule that says they won't allow extremist material on their systems. And these practices are proving to be reasonably effective in limiting the reach of terrorist groups. The Brookings Institution found last year that thousands of accounts on Twitter have been disabled by Twitter as a way of limiting the ability of terrorist groups to reach wider audiences. So one thing we want to talk about today is the role of intermediaries in taking down this harmful material. As Susan mentioned, and as I pointed out earlier, there are countervailing responsibilities as well. The internet intermediaries have to make sure that their systems can still be successfully used as mediums for free speech and association, and we'll discuss that balance in the panel. But another responsibility of the intermediaries is affirmative, to work with government to craft counterterrorism narratives. The solution to bad speech is often more speech, and this seems to fit into that category. As many of you know, the State Department has a program in this area. It's had it since the mid-2000s. They just recently rebranded it as the Global Engagement Center, and it's under the Undersecretary for Public Diplomacy and Public Affairs. The goal of this program is to really work with third-party messengers and groups to get the messages out that would be most effective in countering the pernicious messages that come from extremist groups. They want to bring in many of the Silicon Valley and Madison Avenue experts instead of trying to make government employees experts in social media tricks. Why not bring in the people who are already experts and know all the different ways in which you can wage an information battle against terrorist groups. There have been several meetings with the White House, with tech groups as well, to talk about this kind of issue. So we're going to be talking about that. What should the companies really be doing to aid the government in this area? Are there limits? Will the companies be co-opted in some way? Our panel will dig into these questions in some detail. Their bios are available to you. If you haven't gotten the handout, please get it. It's here. We're joined by Esther Brimmer, who is a professor of practice here at GW, and the former Assistant Secretary for International Organizations over at State. Jason Pielemeier is also at the State Department right now with the Democracy and Human Rights Program. Alexandria Walden is a public policy counsel at Google. Melanzo leads the free expression operation at the Center for Democracy and Technology. And last but not least, Lisl Brunner is a policy director at the Global Network Initiative and an expert in international human rights. So we've got a pretty good panel for you. Look forward to the conversation. Look forward to the discussion back and forth among the panelists and for your questions as well. So with that, let me turn it over to Esther.
Thank you and good afternoon. I'll offer just some opening reflections as we dig into this extremely timely issue. Again, would like to welcome all of you who are here in the room and who are also watching online as well. To say that, in a sense, that this is an excellent example of the intersection of technology and foreign policy issues. And unfortunately, the most recent tragedy, of which is indeed the most recent of unfortunately, a string of tragedies, reminds us of the timeliness of the issues we're looking at. This afternoon, we'll look at some of the specific areas and ways that tech companies can address this question of their responsibilities in the age of international terrorism. And to some extent, that will be shaped by the types of companies we're talking about, whether we're talking about service providers, manufacturers, and so forth. So some of the responsibilities will vary by the area of expertise and emphasis for different companies. This is, in a sense, a newer version of a long-standing conversation. It is not unusual for governments to ask companies to play a role in national security. We can just go back and look at civil aviation. Again, airlines move people as opposed to moving ideas. But if you go back and look at the 1944 International Convention on Civil Aviation that creates the framework for all of our civil aviation worldwide, there's actually in Article 14 a whole discussion on the responsibility of not spreading contagious disease. You literally have a list of the diseases that are provided. States undertake that, but it's airlines that enforce it. It's the airline that actually will have to fly you back if you get off a plane and can't actually enter the country because you don't have the right inoculations. They can ask you for your passport. They can also ask you for your international health card. It's an obligation states have undertaken, but it's actually private companies that have to enforce it. There are many types of versions of this issue. It's not solely related to the information industry, but there are some unique challenges related to it. And I would suggest that indeed, for those companies whose business it is to manipulate content are already, in a sense, implicated in the question about how you address this, and we've already had good examples of some of the actions taken by companies. I would suggest that also the most recent attack in Brussels may suggest some of the new areas, and I would say that already, as I look at what some of the international peace and security community is talking about, they're raising questions about what will be the effects as we rethink privacy. Will, in the transatlantic conversation between the United States and the European Union as we follow up on responses to this tragedy, will there be a reconsideration of the right to be forgotten? Will they rethink that in this context? If we look at the privacy shield now being developed between the U.S. and the EU, will there be additional ideas that will be introduced into that process? To what extent will tech firms be asked to help create more algorithms to help look for malevolent patterns of behavior? To what extent should we be now creating points of contact between companies and law enforcement and other authorities, because you need to have a habit of trust before you deal with crises as well? And what will be some of the specific responses in terms of dealing with ISIS and other tech savvy terrorist firms? I think maybe the questions may be opened again by the most recent tragedy. But as I say, it's not surprising. Companies are not outside of international civil society. And indeed, if we look at how we think about security and allegiance, companies also require governments to be able to take actions to defend copyright and intellectual property. There are responsibilities and rights in both directions. So the ability to work in a constructive and creative environment by being able to bring together the expertise of tech companies to help governments think about how to look at these issues, and for governments to recognize the expertise and needs of tech companies is an extremely important issue. And I think that today and the future will continue to look at these issues. And I'm delighted we have such a strong panel to address these issues. And I look forward to our discussion this afternoon. Thank you.
Great. Thank you. Thank you. Jason, you want to jump in here and keep the conversation going?
Sure. Can you hear me? Great. So thank you to George Washington and to the Software Industry Alliance for the event today, and particularly to Dr. Susan Aronson and Mark MacCarthy for convening this panel, which I'm honored to be a part of. As Mark mentioned, I work in the Bureau of Democracy, Human Rights, and Labor at the State Department, where I head up a team that focuses both on internet freedom and business and human rights. And the issue that we're discussing today really sits squarely at the intersection of those two issue areas, as well as counterterrorism policy, for which the lead in the State Department is the Bureau of Counterterrorism. So let me begin by explaining how we understand those two issues, internet freedom, business, and human rights. We understand internet freedom to be the exercise of universal human rights online, especially the freedom of peaceful assembly, association, expression, and religion, as well as protection against arbitrary or unlawful interference with privacy. We work to promote and protect these rights online through traditional bilateral, multilateral, and public diplomacy, as well as with non-governmental stakeholders, including folks here on this panel. One of our approaches that's been central to our work on internet freedom has been to ensure that successive multilaterally endorsed resolutions at the Human Rights Council and at the UN General Assembly recognize and reinforce the principle that the same rights, the same human rights that people have offline also apply online. Separately, we understand the area of business and human rights to be a recognition of, one, the fact that states have a duty to protect against human rights abuse, including by business enterprises within their territory and or jurisdiction. Two, the fact that business enterprises are required to comply with applicable law. and that they have a responsibility to respect human rights in their practices. And 3, that there is a related need for rights and obligations to be matched to appropriate and effective remedies when breached. So this is the protect, respect, remedy framework that's set out in the UN Guiding Principles on Business and Human Rights, which were endorsed by consensus at the Human Rights Council in 2011 and have really been developed in a number of ways since then. My team in DRL works diligently to encourage dissemination and implementation of the guiding principles around the world in various contexts and sectors, including online, and you'll hear later from Lisl. Actually, everyone else on the panel is involved in the Global Network Initiative, which is an effort to think about the responsibilities that, in particular, internet companies have in line with the UN Guiding Principles. So it's a sector-specific application of those principles. Use of the internet for terrorist purposes is the lexicon that the U.S. government, and in particular my counterterrorism colleagues, have chosen to refer to a range of problematic activities undertaken online by terrorists, including propaganda, recruiting, terrorist finance, planning terrorist activities. It's an acceptable, albeit dry and wordy phrase, but just want to apologize that I'll continue to sort of pound it the rest of my remarks. Strategies for how best to counter use of the internet for terrorist purposes vary and are being constantly modified and adapting to an evolving threat, which makes it a particularly challenging policy area to work on. In my team, we see our role as working within our own government, with other governments, and with other stakeholders, including internet companies, to ensure that the strategies that we're employing against this threat are consistent with international human rights obligations and commitments. To be clear, some of the activity that falls under the broad rubric of use of the internet for terrorist purposes is per se illegal. For the purposes of today's talk, I'm going to focus on the actions and the behavior and the content that is not illegal, but it may nevertheless present serious policy or security challenges. As with hate speech, which is a sort of related issue in some ways, much of the content that terrorist groups espouse online is offensive, but that doesn't necessarily mean we should ban it, or even, and this is the key point, that banning it would do any good. While we routinely condemn this speech at the highest levels of our government, we also recognize that suppression of expression can be counterproductive. Can raise the profile of offensive speech, and it can also cause it to fester in dangerous ways and to move to deeper and darker places. The challenges posed by the use of internet for terrorist purposes, in particular the adept use of social media by Daesh as a tool for propaganda and recruitment, are causing us to re-examine this approach and these tactics. This is a really serious issue, and I think everyone should be aware of the fact that it's causing us to think very deeply and seriously about how we approach it. Private companies also obviously have a critical role to play, as Mark pointed out, in defining the terms under which they will allow their own customers to use their services. These companies are not instrumentalities of the U.S. government and thus are free for business reasons to restrict content in ways that the government cannot because of the First Amendment, as well as our international human rights obligations. For instance, companies can take voluntary action to remove violent extremist content that violates their terms of service but might nevertheless be protected speech here in the U.S. It's not surprising, therefore, that the U.S. government is talking to and working with companies to share information about our respective efforts and to consider how we can work together to counter terrorism online. As many of you know, and as Mark referred to, in January, senior White House and administration officials met with representatives from a number of leading technology companies in Silicon Valley as part of the administration's continued dialogue with tech companies to ensure we're bringing the best private and public sector thinking to counterterrorism. The administration will also be including civil society organizations in this broader conversation to ensure that we're hearing from a full range of stakeholders. So as we work together, all of us, to counter the use of internet for terrorist purposes, we really must work carefully to ensure that we do not unintentionally or unduly limit the promotion and protection of human rights online. Again, that's really where my office and my team come in. That's our objective in this broader conversation. So in closing, I want to suggest 3 sets of concerns that we should all keep in mind as we develop, implement, and analyze these efforts. As with any good remarks, I'm going to awkwardly title them in an alliterative fashion in the hopes that this will keep them, make them more memorable. So practicality, pretext, and precedent. First, we must pay particular attention to the practicality of proposed strategies. So efforts to address terrorist content online, whether through removal of content or accounts or by means of counter-messaging, must be carefully and thoroughly thought through. narrowly tailored and transparently developed and implemented. In other words, we need to work in alignment with our human rights commitments, and they should be developed and implemented in accordance with the principles of legality and necessity. Furthermore, in designing these approaches, we must be aware of the practical, jurisdictional, linguistic, cultural, and technical challenges that are inherent to the internet and global social media platforms. For instance, efforts to limit the implications of certain action to particular geographies or to avoid impacts on home country citizens can be really, really difficult, as everybody here on this panel, and I think probably the rest of you can appreciate. Second, we must exercise precaution about pretext. So human rights organizations have been appropriately concerned about how efforts to encourage and sanction actions against terrorism or extremism have and will be used to justify efforts to repress protected activity and crack down on political opponents, religious minorities, and other vulnerable groups. Given the lack of commonly respected definitions of terms like terrorism and extremism, we must be vigilant against the likelihood that mobilization and coordinated action against the use of internet for terrorist purposes may be used to justify not only repression by autocratic governments, but also much less controversial but nevertheless problematic suppression, even by democratic governments, of hate speech and of views critical of those in power. We're seeing examples of that all over the world, in Malaysia, Saudi Arabia, Ethiopia, and elsewhere. Finally, we must be perennially prudent about the precedents we are setting as we attempt to address the use of internet for terrorist purposes and other challenges such as hate speech online. Well, this is not the first time the global community has mobilized a multi-frontal approach to addressing problematic content or behavior online, spam, pornography, those are other examples. The high-profile and well-resourced nature of this particular challenge make it quite likely that the mechanisms we develop, the standards we set, and the actions we take will continue to apply not only for future iterations of this evolving threat, but to other future approaches to the regulation of content and behavior online. So again, just to kind of reemphasize practicality, pretext, and precedent, those are three things I think we all need to keep in mind. I think really, and I mean this sincerely, the extent to which we're able to navigate these perilous shoals with regard to this issue of the use of the internet for terrorist purposes is not only going to dictate whether our efforts to address this threat will succeed, but whether they may well determine whether we are able to preserve the internet's valuable role as a mechanism for free expression, free association, and peaceful assembly. Thanks.
Jason, thank you. So Alexandria, or Alex as I call you.
Alex.
Yeah.
So thank you, Susan and Mark and GW and SIA for hosting this event. I'm really grateful to be a part of it. So, you know, at Google, we take these issues about terrorism and extremist content and controversial content more broadly very seriously. And so this is something that we have been and continue to be very thoughtful about how we approach it and how we engage with all of the stakeholders in the space to make sure that we do have the most thoughtful approach. So just to sort of set out a little framework for how we look at this, there are more than 1 billion people, almost half the people on the internet that come to the YouTube every month. And so we work really hard to maintain a safe and vibrant community for those people. And keeping YouTube free from dangerous content, illicit content, keeps users safe, and it's important for our business. So we have in place community guidelines, and those are meant to spell out what is and is not allowed on YouTube. We do not allow extremist propaganda. We don't allow incitement to violence or glorifying violent acts. Videos that contain threats or that promote hatred, terrorist recruitment videos, training camp videos, beheading videos that are posted by perpetrators. All of those things are already and explicitly called out as impermissible under our community guidelines. So when a member of the community flags a video, we have a team of reviewers around the world that are reviewing those flags 24 hours a day, 7 days a week. And so that is one of the most important ways we are taking down content that is falling within the realm of what we find problematic for our site. there are 100,000 videos each day that we take action on. Each day and take action in under an hour. So in the past, that's millions of videos over the course of a year, right? And one thing that I want to note is that it's important that some of those that we have exceptions, and that one reason why some things that people may find sort of offensive in terms of violence or other kind of related issues is that we think it's important to document things like atrocities and human rights violations that are happening around the world and that do have newsworthy or documentary value. And so that's one of the things that we're cognizant about when we're thinking about what is or is not falling in the lines of what violates. And so ultimately, we think that content can be a force for good, right? It can educate and mobilize people in really important ways. And so we have to be thoughtful about that when we're thinking about the things that we take down and leave up. I just wanted to note sort of a few things that we do have in place that are important to note in terms of thinking about broadly all of the things we're doing. We have a program called Trusted Flagger, and that is a way in which we partner with NGOs and some governments to let them flag content that is violative of our terms of our community guidelines. In addition, and I think this is sort of the most important piece for us, is that we value counter speech, and that's something that we as a company are committed to strengthening. We work with organizations and stakeholders and thought leaders around the world to help them understand how to best use our platform to amplify their messages. And it's something that we have been doing. We've hosted events in Asia and Europe, in the US, and there are more to come. And so that's an important way that we think we can use our platform that is, the strength of it is that it is a place where people can share their ideas and tell their stories. And so helping more organizations do that better is where we play at our strength. So I think we'll probably talk about a lot more of the stuff that we're doing, but ultimately, maintaining a space online that is safe and free from hateful propaganda it's not easy. And so for us, it's important to continue to work with all the stakeholders in this space to find the best way to maintain the importance of a free expression platform online.
Thank you. And Emma, you're on.
Thanks, Mark. And thanks to you and Susan for pulling together this great panel, and to all of you for coming out for free lunch this afternoon. So as we've all been discussing, there have been so many calls over the past year for internet companies to do more about terrorist propaganda online, about the use of the internet to radicalize and recruit people to fight for ISIS or to commit other kinds of hate-based actions. And this makes sense. I mean, as Esther was saying, there's a long tradition of interaction between government and companies around public policy issues. In the U.S., as Jason was describing, just this year, there have been 2 very high-level meetings between tech firms and administration officials on this topic. In Europe, there is a major emphasis on public-private partnerships as the way to pursue kind of the fact that ISIS uses the internet in a way that's similar to the rest of us, and trying to come up with ways to address the online content piece of the much broader fight against ISIS. But I think one of the things that we need to really keep in mind as we see all of this, these calls from government, this pressure from government on companies to do more, is where we're seeing the blurring of the line between government action and private action. And so I figured I'd talk about a specific example of this, just to give us something a little bit more concrete to discuss. In the United Kingdom, there's a program called the Counterterrorism Internet Referral Unit. This is an official government program under which the Metropolitan Police seeks removal of content from different web services like Facebook, Twitter, YouTube, not by going to a court, but by using companies' content flagging systems, their terms of service enforcement. This is, and this has been discussed a little bit already, as Mark and Jason were both pointing out, companies can and are much more restrictive in terms of the kinds of speech they allow on their individual platforms than governments can really pursue under the law. And there's a lot of good reasons for this. As we've discussed a little bit already, the freedom for companies to create terms of service or create a content policy allows them to create a certain kind of community, to host, to deal with problems like online harassment, or even just to say, this site is going to be focused on a specific topic. This is a knitting blog. Do not talk about crochet on this blog. We will delete your content, right? I mean, there's a lot of different kinds of online content hosts, from the very biggest companies to people running individual websites, make use of this ability to craft terms of service that are way more restrictive than what you could go after under the First Amendment or human rights law. But that means when governments start using systems that are designed to enforce those terms, we're seeing government action that is going well beyond what they would actually be able to seek removal of from the web if they went through due process, if they went to a court, if they had judicial review of the requests, if they gave the speaker the opportunity to make their argument about why their speech doesn't actually violate the law. And so to see this kind of embrace, not just in the UK, but also now Europol has a similar program. It was included in the agenda for discussion at the Silicon Valley meeting that the administration had back in January. Seeing kind of this interest in using these informal private enforcement mechanisms as a way not just for users of a site to seek material to come down, but for governments pursuing a particular public policy objective to seek content takedown, that raises some really big flags to me. Because I think, as Jason and Mark were both saying, this isn't the first time that people around the world have been asking questions about public policy around online content, and it's not going to be the last. This, I think, fits squarely into the kind of precedent alliterative bit that Jason was talking about. If we sort of condone or embrace governments circumventing our due process rights, not going to courts, not having independent review involved, but just realizing that there's an easier, more efficient way to get the stuff they don't want to see online taken down, if we condone that now, there's no stopping the kind of the spread of this sort of approach to use by a number of other governments and to cover a number of different kinds of content. So I'd say that one of the big risks, too, that we see in this kind of environment of such kind of intense scrutiny on what the companies are doing and pressure from governments, actually going back to the UK, is in their, back in the fall, the United Kingdom came out with their counter-extremism strategy, which laid out a number of different things that they were doing kind of in the sphere of countering violent extremism. But one of the points of that strategy was calling on companies to make their content policies and their terms of service more restrictive, so that more information could be removed online. And I think that's just a kind of a good example of just how far down the path we can go into really blurring this line between what is private voluntary action by companies and what is government action kind of coming in through the back door. So in this environment of such kind of pressure from governments on companies to do more, to be more responsible, to change their policies or whatever it may be, I think we really need to see more transparency both from governments and companies. And so I thank my government and company colleagues for being on this panel today to talk about this, because I think the ultimate risk is that we really just undermine people's faith in internet platforms, that if it's felt that especially the big internet companies, which are primarily based in the United States, are kind of working closely with the US government to affect the kinds of content that people see online around the world, that's not good for anybody. It's not good for the companies. It's not good for individual speakers. And I don't think it's ultimately going to help promote the kinds of policies and strategies that the government's looking to pursue. So with that sort of doom and gloom, here are all the risks. I'll turn it over to Lisl.
Yeah, thank you. And I think that was a bracing reminder of some of the limits that we are facing as we go down this road. But we'll have a further conversation about that during the discussion. Lisl?
Great, thank you. And thank you to Mark and Susan and to GW for hosting us today. So I work for the Global Network Initiative, which is a multi-stakeholder initiative that brings together ICT companies, including Facebook, Google, Microsoft, LinkedIn, and Yahoo, civil society organizations, including CDT and Human Rights Watch, investors and academics to take a common approach to protecting freedom of expression and privacy online. Its foundation is a set of principles which are based on international human rights standards and which create a framework for responsible company decision-making when they face requests that could impact the freedom of expression and privacy of users globally. The accountability process used by the GNI uses independent assessment to verify that companies are actually implementing the principles. And as Jason mentioned, these principles are consistent with the UN Guiding Principles on Business and Human Rights, and they're a way in which companies in the ICT sector can implement their responsibility to respect human rights. So we have participated actively in discussions around this issue. We've launched a policy dialogue on extremist content in the ICT sector. We've taken part in meetings of the UN Counterterrorism Committee to discuss this topic and kind of come up with a common approach. And I'll go back a little bit to the GNI later. I've been asked to give a little bit more of an international human rights perspective. So the internet is one of the tools that terrorist organizations like ISIS have used to recruit, to raise funds, to radicalize. And as a result, many of the policies that we've seen kind of around terrorist use of the internet, as my colleagues have mentioned, have been directed sort of eradicating terrorists from the internet, eradicating extremist content from the internet. And all of this has implications for the right to freedom of expression, which is enshrined in Article 19 of the International Covenant on Civil and Political Rights, as well as in regional instruments. Article 19 establishes the freedom to seek, receive, and impart information of all kinds, and it's been called one of the indispensable conditions for the fulfillment of the individual and the foundation stone for every free and democratic society. According to Article 19, any restriction that government places on the right to freedom of expression must be compliant with the principle of legality, which means that it's pursuant to the law, which is written in clear and precise terms, which is accessible to all, and which is consistent with international human rights standards. It must pursue a legitimate aim, and national security and the protection of public order are legitimate aims. And it must be necessary and proportionate to that aim, meaning that there must be a direct connection between the expression and the threat to that legitimate aim, and the restriction should be the least intrusive means of achieving that aim. So there are several sources of international law that require states to prohibit incitement to terrorism and to take certain actions with regard to terrorist use of the internet, including Security Council Resolution 1624 of 2005, which calls on states to prohibit by law incitement to commit a terrorist act or acts, Resolution 2178, 2014, and the Council of Europe Convention on the Prevention of Terrorism. And all of these instruments, by the way, emphasize the need for these activities to be consistent with the respect for international human rights law. In terms of legality, how does a state define incitement to terrorism in a way that's compatible with Article 19? There continues to be no internationally agreed upon definition of terrorism, although the Council of Europe Convention on the Prevention of Terrorism kind of tries to list certain acts and certain international instruments that get close to that definition. But we've seen, around the world, countries that are using counterterrorism laws to suppress political speech, to go after human rights defenders, to go after bloggers. Some examples that are somewhat concerning include in Tajikistan, companies have been asked to block hundreds and hundreds of web pages which are somehow linked to terrorism. I believe YouTube is still blocked in Tajikistan, or has been on and off for quite some time. In France, last year, after the attacks of January 2015, a comedian was convicted under counterterrorism laws for posting on his Facebook page, "I feel like Charlie Koulibaly," under a law prohibiting glorification of terrorism. So the Human Rights Committee and the current and former special rapporteurs for counterterrorism of the United Nations, counterterrorism and human rights, have emphasized that laws prohibiting encouragement of terrorism, extremist activity, praising, glorifying, justifying terrorism have to be clearly defined to ensure that they don't constitute an unnecessary or disproportionate interference with freedom of expression. Former UN Rapporteur Martin Scheinin recommended the definition contained in Article 5 of the European Convention on the Prevention of Terrorism as a best practice. With regard to necessity and proportionality, governments always have to ask have to look at these policies in the context of the things that are happening. Radicalization is a complex process, and the internet is part of that process, but researchers have found that many different factors contribute to radicalization. And most often, they're factors within your community that have little to do with the internet that kind of gets things going. In the United States, since 2001, we've had a little more than 200 prosecutions for terrorism. We've had somewhere between 200 and 250 foreign fighters go to Syria and Iraq. Are measures that are geared toward eradicating extremist content or content that is related to ISIL from the internet really a necessary and proportionate means of responding to that threat when there are other threats to public order and national security as well. And this event may come, this calculus may come out differently on the other side of the Atlantic, but it's very important to ask these questions when thousands of Europeans are going to become foreign fighters, and events such as the event that happened in Brussels are becoming more and more frequent. But we must place them in the context of legality, necessity, and proportionality. So recently, the UN Secretary General presented his plan of action to prevent violent extremism, and he highlights all of these points, that radicalization is a very complex process. And he said, "I'm convinced that the creation of open, equitable, inclusive, and pluralist societies based on the full respect of human rights and with economic opportunities for all represents the most tangible and meaningful alternative to violent extremism." He proposes many holistic measures that are appropriate for responding to this threat. And so I'll conclude and then leave some space for questions. So from the Global Network Initiative's perspective, what can companies do to respond to this threat? Well, we have a set of principles and a set of implementation guidelines which govern responsible company action with regard to various different types of government actions that would impact freedom of expression. And, terrorist content or extremist content is one of them. And these principles and implementation guidelines indicate that companies can require that governments follow domestic legal procedures when they request that content be restricted or that, accounts be removed, that websites be blocked. They can seek clarification or modification of orders when these orders appear to be overbroad. And they can communicate with their users. Clarity on the policies and procedures by which the companies remove content, clear and timely notice to users when the content has been restricted, if this is permitted by law, are good steps toward transparency in this regard. And I'm happy to take your questions. Thank you.
All right, that was a great setup from all of you. Thank you so much for a nice range of discussions. I want to start things off by asking a threshold question that we may get agreement on, maybe not. And it keys off from some of the remarks from Emma, noting that the terms of service that many of these intermediaries have put in place are significantly more restrictive than the First Amendment, what the First Amendment would allow. And I got the sense that she at least thought that was a reasonable position to take. And I'm going to raise this question for all of you, whether whether that is a reasonable thing for the intermediaries to be doing. And I raise it because at least, some thinkers in this area, including Jeff Rosen, who's a law professor here at GW, have suggested that what we really need is a little bit of U.S. free speech imperialism in this area, and that the intermediaries really shouldn't be any more restrictive about content than the U.S. government could be if they were seeking to censor speech. Now, obviously, they're going to, create rooms for some discussions, and some things aren't appropriate for that kind of room, so you'll tell them to go somewhere else. But that's sort of like time, place, and manner discussions. But should intermediaries really be in the business of further restricting content more than would be restricted by the requirements of U.S. law? Or should they simply say, my job is a platform provider, and all I want to do is provide an opportunity for people to speak. If you're not breaking the law, then have at it. And related to that, I want to push on Emma's question about the use of government officials or employees as people to take advantage of the terms of service, and not through formal government action. They don't file a court complaint. They don't use a provision of law, but they use the same provisions of the terms of service that are available to anybody, only in a concerted and disciplined way. They take efforts to stomp out certain kinds of content that they've decided as a matter of government policy that they don't like. Now, of course, other groups do exactly the same thing. Anonymous has declared war on ISIS, right? And they use the terms of service in a systematic and organized way to try to take that content down. We're all a little nervous when government does the same thing, but the question I've got is sort of why? Now, if Anonymous can do it, if I can do it, right? If I can tell my class at Georgetown University, why don't we all just see how much stuff we can take down, and we do it in an organized and disciplined and systematic way, why is that, okay? But when the government does it, somehow it becomes illegitimate. So those are the two questions. Should we really have tighter terms of service, and really what's wrong with the government using those terms of service in a systematic way to get content taken down? Right. Anybody want to start off with that? Yeah.
Well, just to take that last point that you made, I think you were framing it like somehow when government does this, we think of it differently, and why. I would counter that the way we approach government efforts to censor in this country is, like it's spelled out in the First Amendment, Congress shall make no law. The presumption is that government has to justify what it's doing, not that we have to justify why we are concerned about government censorship, but that if government wants to restrict the availability of certain speech or ideas or expression in public debate, they need to make a very strong showing as to why that's appropriate. We have when we're talking about content-based efforts to restrict speech, we get into First Amendment strict scrutiny analysis, very similar to the standards that Lisl and Jason were both discussing from international human rights law. Restrictions need to be narrowly tailored. They need to be the least restrictive means and actually effective to achieve the compelling government interest. So that's what government is charged with. They are the ones who have to justify to the public whose access to information they're affecting why what they're doing is legitimate, not the public needing to justify why what government is doing is illegitimate.
Let me just let me go back to my 3 Ps in response to the second question and back into the first one. So what's wrong with government taking advantage of terms of service? Well, I think it all depends on sort of how governments may do that, but I think it really touches on all 3. First of all, as a practical matter, there are policy issues and concerns. We're debating this issue internally, and there are parts of the government that are very concerned about taking this information off of the internet where it is visible and readily accessible to them, because their job is to track these terrorists and identify how they try and communicate and articulate their message, and to either counter that through messaging or counter that through legal action, law enforcement actions. So there are those kinds of sort of practical concerns. then, on the sort of pretext point, clearly what the UK is doing is it goes beyond what the US has done. But we wouldn't say, I don't think we have taken a position where we think it is necessarily in violation of their international human rights commitments, but we do worry about how those kinds of efforts can be used by other governments to justify much more restrictive content blocking or censorship. And that's a real concern for us. And then on the issue of precedent setting, it is a really important, I think this is a real threshold issue. We sort of tend to take the line that I articulated earlier that, these are not new challenges. The internet is just a new platform. We shouldn't, think about reinventing or redefining rights, and that's true. But the internet is increasingly the way people communicate. And so the combination of both government becoming more proactive in the way it tells companies what to do and the liberty that companies have because they're not states and don't have the same obligations creates a real potential for creating a much more restrictive environment for speech. And I think very hard for people to argue against those kinds of measures in this specific context because we all think Daesh's content and conduct is reprehensible, but we have to think about this as a bigger picture issue again, the steps we take here are going to be the reference points for future action. So let me just touch on the free speech imperialism. I would argue that there are probably many in the world who feel like we are doing a pretty good job of continuing to pound out our American free speech imperialism. Maybe not Jeff Rosen, but I think the fact that we have not taken some of the steps that our European partners have is, in fact, a reflection of the fact that we have a very different understanding. How very different it is really depends on the circumstances. And the combination of the fact that it's the U.S. government that is sort of most cautious about these kinds of steps, and the fact that U.S. companies are the ones who are the mediums, the intermediaries, and they have also been exercising more caution than many governments would like to see in terms of being more proactive about speech takedown, has fed a trope, a meme, a sort of understanding among many that, both the U.S. government and U.S. companies are not taking this issue seriously enough. And that's resulting in real pressure. I mean, Emma made the point that, trust in the internet may be prejudiced if we do too much. And I think that's a very fair point. I also worry, though, that if we don't do enough, there's real potential for backlash against the American companies and other companies, backlash against sort of the U.S. government's view of free expression, and the broader argument that we make that suppression of speech is not the best way to address bad speech, but rather, as you put at the beginning, more speech, countering that speech. That's really being actively debated. It's always been under debate, but the pressure on that debate is getting hotter and hotter.
Esther.
Just 2 points to pick up on the last portion of your question, what other panelists have said, that indeed there is always the issue when you're dealing with governments in the state because they have the coercive force as well, that ultimately they have the link to the use of incarceration and other aspects of the law enforcement capacity. Therefore, you will always need to have a greater set of rules that manage the role of states. That's why the constitutional provisions are so important. But I would also flag that indeed there is a long history here as well. You cited Article 19, but of course, if we look at both Articles 19 and 20, the United States has always had its reservation on these very points. And so all that history comes to this conversation as well. Even when talking to close partners who share some of our views on freedom of speech, they see us as having a distinctive position, as we've had often in these issues. Thank you.
Let me just add one thing. I mean, I think one of the things that's, again, this is really a useful issue for people to give their views and to ask questions of all the panelists here. But on this issue of what companies should or shouldn't be doing, so we've got the example of the UK sort of going further than what the US has been willing to do to date. You've also got a proposal, I'm not sure where it is exactly now, but there was a proposal in the European Parliament to actually make companies criminally and civilly liable for not doing enough. So that's sort of erasing the broader principle of, or reasserting the broader principle of intermediary liability that you mentioned up front, Mark. And I think that's a much more serious precedent that could be set if we're not more careful about how we manage this issue. And so there's a range of policy options that are out there that states are sort of looking at. And we have to be very careful. That's just my underlying message.
Careful is always good. And it was good of you to point out that there's a risk of doing too little as well as a risk of doing too much. But let me see if I can sum up. I mean, I thought I got a consensus that maybe the terms of service for the intermediaries should be tighter than the First Amendment. Is that a fair summary or not?
I mean, I'd push back on that a little bit. I think one thing that we have to keep in mind when we're talking about terms of service is, it's not just how are the biggest, the global giant platforms like Google and Facebook and Twitter, who have hundreds of millions, billions of users. It's not just what do they do when they set their terms of service, but if we're talking about legal requirements or kind of freedom under the law to set terms of service, we're also talking about much smaller sites than that, all the way down to the level of the individual person running their own website that has some kind of user-generated content bit, like a comment field or some kind of interactivity. And so that, when I come at this question of under the law, what should be required or permitted by website operators, I've got to keep in mind that individual operator as well as the giant companies. And to me, the ability for any the still wonderful aspect of the internet that I wish more of us kind of took advantage of is this fact that any one of us can attach a device to the end of the network, can create our own application, our own website, our own forum for our speech, and that from that angle, of course, we should have the freedom to set our own terms. Maybe those terms will be more restrictive than what the First Amendment allows government to restrict, and maybe they won't. And I think it's got to remain fine for a host of other people's content to also set lines that say, look, no, we'll take down incitement to imminent violence, imminent lawless acts, like the First Amendment standard, and that's it. We'll and toe that line of only removing content that violates the law. So I think there's any number of reasons why the biggest companies do set policies that are more restrictive, and we can talk about that, and I understand that and think that is, that makes sense. But the other part, the freedom to do no more than taking down content that is manifestly unlawful, is also an important piece of the environment.
Yeah, got it. So there are some audience questions beginning to pop up, but I wanted to turn the question to one more, to the other side of the conversation, not to the negative, to the responsibilities to take stuff down, but to the affirmative, to the working together in partnership with the government to craft a counter-terrorist narrative. And I'm wondering if we agree that that's a good role for the intermediaries. I'm struck by the fact that tech companies met with the White House publicly to planting messages, right, on the internet, right, that would tell a government story. Now, think of this as if it were the old media. Think of this as if it were the Washington bureau chief of the Wall Street Journal and the head of the ABC News operation here in Washington wandering over to the White House to say, what messages would you like us to deliver in our newspapers and in the evening news? The Fourth Amendment pundits would run screaming from the room. There would be outrage all across the political spectrum if that were to happen. But when tech companies sat down with the White House and talked about common messaging, there was no such outcry. So why the difference? Why is it apparently okay for tech companies to have this kind of conversation and to work together with governments in this way? But the old media, the print media, the broadcast media, wouldn't think that that's an appropriate role for them to play at all. So let me throw that open and see what people say.
I just wanted to sort of clarify around the way that, we as a company engage with government. We engage with all sorts of actors from various agencies, international organizations, and civil society. And the way that we approach counter-speech is that we engage with organizations and sort of thought leaders who are in the space to help them amplify their messages. And anybody can have a YouTube channel, and so we would like them to know how to use it as best they can, and so they should know how to, create compelling content and do distribution and all of those things. And so it's not, I think the framing, it's not that we're working with government to get their message out. That's certainly not, I think that's not the way that we would talk about it. We work with all sorts of folks and are helping them amplify their messages. And the idea is to make sure that there is more good content out there than the stuff that's harmful. And so when you are looking for, when you look for jihad, what you find is things like imams talking about, important values and things like that, so that people are finding good, important, compelling content rather than things that are harmful.
I'll just note that, so I'm not going to take a position on whether it's a good use of government resources. I think it is, as long as we are very careful to, and cognizant of the sort of legal issues and the policy issues, some of which I mentioned, that can be can get caught up in government cooperation with companies on issues related to content. I don't think it's impermissible. I do think, it's also important to think back that, there are precedents in our own history where the government has, passed laws to both prohibit and promote propaganda. I mean, during wartime, World War II in particular is a sort of classic example. But there is also we have authorization for the use of military force against ISIL in certain areas of hostilities. What's challenging sometimes now is that the internet is not confined geographically in that same sense. So when you're going after content that may be originating from within those areas, either in a sort of reactive way or to try and counter it with other messaging, you are also having that impact on the broader internet, which is global. So it makes it really complicated.
Yeah. Well, it's a great question, Mark, because one of the things that we've learned about effective counter speech and counter narrative is that it's got to, and when I say effective, I mean it's speech and information that is being, delivered in a way that actually stops a process of radicalization, stops a person from deciding to up and go to Syria to commit acts of violence. So something that really, it's not about, successful counter speech doesn't have to be about like changing someone's total mindset or, brainwashing them into thinking exactly what you want them to think. It's about disrupting that actual, that last step, that actual commission of a violent act or a terrorist act. And what we find is most successful is narratives, counter speech that's coming from credible and authentic voices. And this is where I've got some concern around the way you framed what we kind of heard about they're calling it the Madison Valleywood Project, the Madison Avenue, Silicon Valley, and Hollywood coming together with the U.S. government to figure out counter messaging. That really doesn't strike, I think, anybody as very authentic or credible necessarily. And I think there's a lot of work that, we've heard a number of the different tech companies, Google and Facebook and Twitter, all doing work to, reach out to NGOs to help them understand how to use the platform better, or to go through kind of basic media training, like these are the components of a successful message. This is, I think Facebook and the nonprofit organization Demos did some research on what actually makes a post go viral on Facebook, like things that could really help somebody with a genuine point of view to express, get that out there better. And that kind of training or that kind of information for your true counterspeakers could be very useful. But I worry that if it comes under this with this shadow of, is it just the U.S. government pulling the puppet strings, it's just going to undermine all of those efforts.
Well, I think we've reached the point where our audience is going to have to rescue us from silence, and so let me point the finger over at the gentleman in the front row who's been trying to get in for about 20 minutes now.
Thank you. It's Dana Marshall, and this has been a really very valuable discussion here. And counter speech is, I think, we've well explored the hopes and the sort of fears and the thoughts about how effective or not that is. My question, I really want to put this, I don't have a particular hidden agenda here, but just wanted to, nor is this an area of my expertise, so I'm really interested in hearing from this audience, this panel, I mean, why is it apparently impossible to stop somebody that's sitting in a bedroom in Minneapolis to be radicalized by somebody in Syria? Is this a technological problem? Is there no way technologically that can be done? Because clearly, one or two more of these attacks, and I think there'll be more and more people that are really going to be focusing on a direct action. I mean, not the Hollywood, Silicon Valley, Madison Avenue, but directly stopping that communication through technical means. Is it a technical problem? Is it a legal problem? Frankly, is it a philosophical problem? Is the view that was up to now, perhaps yesterday changed it, about Apple not releasing the software to open up that phone, is that what is stopping this? So can we find a time in the future that we can actually break that communication directly? Thank you.
So let me give the panel a chance to jump in response to that, but let me respond. I don't think it's a technical issue. It's not that I mean, in some cases you can have technical filters that can do this kind of job. When you're dealing with speech as complicated as this, I don't see how you do it. I mean, imagine, for example, a professor here at George Washington who makes the argument that ISIS does use brutal and inhumane and indiscriminate means, but their cause is just. And they argue, given the welter of confusing loyalties and histories in the Middle East, that they have a legitimate interest in establishing their own state. Now, can you find the technological filter that would allow that to go through, but not to allow other kinds of speech that is more directly related to inciting to violence? I don't see how you do that in a technical measure. You have to have some sort of human judgment involved in deciding that one kind of speech is no good, and the other kind of speech is just a conversation about a political issue that needs to be fully aired and discussed.
I think there's a technical way, not to belabor this, but just to maybe a response to that. If somebody gives a massive online course and makes a statement like that, although I certainly would disagree with that, but that doesn't matter. You could register somehow, it seems to me technically, this is coming from George Washington University, USA. This is not coming from Syria to get somebody to blow up the Washington subway tomorrow. That's a different thing in my view. I think it's a balance.
I just make one point on kind of going back to the practicality issue. So you could block, Google Canon does block, for instance, people from certain geographic areas based on their IP address, their internet protocol address, from accessing certain services as a part of the implementation of their compliance with U.S. sanctions. So that happens and can be done, but you have to be aware of the sort of broader impacts that could have. So sort of prohibiting people from Syria being able to reach out of Syria on the internet would not only block Daesh and all of the sort of messaging that we might think is pernicious, but it might also block human rights activists who are trying to document atrocities, which could be useful for later transitional justice purposes. It will block people who are reaching out for help. It would block people who are inside that country working for foreign intelligence organizations and others. I mean, they may have more sophisticated means to communicate, but there would be, I think there would be many concerns about how much unintentional or unintended sort of consequence you would have for implementing those kind of policies.
Blocking everything, and I'm saying it's a balance. Sorry.
Rob Pecoraro with Yahoo Tech. Can any of you speak to the use of social media metadata as a tool to identify suspects, or maybe in a sort of pre-crime way, identify people that you might want to keep a closer eye on in case they were likely to become suspects?
Anyone want that?
Yeah, I mean, I'm sure that is a topic that law enforcement can speak to more generally. I'll just say from kind of human rights policy perspective that, again, I think we'd be concerned about that kind of, I think certainly there is a degree to which companies are already using all kinds of metadata for marketing and advertising and other kinds of legitimate commercial purposes, and that's it's one of the things that the U.S. government is trying to learn about and understand better through these conversations that we're having with tech companies and Madison Valley consultants and others. But when you sort of take that and then apply it to conduct that the state could potentially bring its coercive authority behind, then you have to really start to be concerned about, would that kind of if somebody mistargets you with an advertisement for a new car, it doesn't have a lot of sort of negative potential social implications. If someone mistargets you with a message, because they think you might be susceptible to ISIS messaging with a counter message, maybe that's also not so bad. But if they mistarget you with a drone strike or or any other kind of more serious conduct, then it really is much more consequential.
May I ask,
Esther,
just ask a question to just drill down a little bit on that question? Could it be that there might be more subtle and nuanced and time-limited use of metadata for focus? So, for example, let's just walk back a week ago. We had an arrest on Tuesday in Brussels. We had the follow-on arrest on Friday. There was an argument that, we don't know a lot, but that at least two of the attackers were probably known figures to intelligence in Belgium. And so one question is, at points of crisis, when one could anticipate additional concerns, is there a role at that point for increased focus on individuals who are affected all the way on the equivalent of a watch list? Is that a place where there could be a more nuanced, focused, as a time-limited approach, or that would probably again be supported by court action to enforce legality? Is that an area where we might see more cooperation?
I think that's a promising area. Just quickly on your example, Twitter is doing stuff like that. They do manual review to find the problematic accounts, and then they use algorithms to see if they can identify other accounts that are like that, and then they queue them up for manual review, and that's a way of finding some of the additional problematic accounts. Okay, you had a question here. Yeah.
Oh, okay. So my name is Ian Tang. I'm a student here, and thank you for speaking with us. I think my question references what Mark said earlier about web companies working closer with the government. And I think an observation that I made was after Snowden and all those reports came out, there was fierce backlash against companies working with the government. And then a year later, when Paris happened, it was on the opposite side of focusing more on security and being able to work together. So I think my question more focuses on when three examples quickly. So, for example, the Apple iPhone issue. The other issue with Gmail recently had made arrests for a user who had child pornography on his account that violated terms of service. And the third would be in China when China hacked activists' accounts. So basically, equally as important as public content being censored or removed or taken down from the internet, who ultimately decides for private content what happens to that, and if Google or Apple doesn't want to do that, what happens, and then ultimately what role do companies also have to balance consumer privacy for people who are following the terms of service and aren't violating that. Yeah, thank you.
Lots of questions all at once. Anybody want to jump in?
Well, I can just sort of say in general about sort of what you raised about Gmail, and I can say more generally about what we call CSAI, child sexual assault imagery, is that that's sort of different than this context, because when we're talking about that, sort of possession is per se illegal, and there is more technology available to sort of identify those things and make sure they kind of come down immediately. In the context of terrorist propaganda, extremist content, for all the reasons Mark raised, it's context specific, and so we can't just automatically take things down. They need to be flagged and reviewed by a person who's going to look at it and decide if it is a violation, or if there are other sort of documentary or newsworthy reasons, or if there's context around it that is, it's an educator trying to have a discussion, like an academic discussion around something, versus a training camp video that has no value but to incite violence. And so I think there's just sort of different contexts around those different types of content.
And kind of to follow up with that though, but what if the terrorists are more than like YouTube? What if they're using Gmail to send or communicate to each other? In like, what responsibilities does Google have or private companies have to take those accounts down?
Yeah, I think, well, what we have, our responsibilities are what we have outlined in our terms of service, and then what we do to comply with law enforcement, and that's across all of our products.
Well, and I think one of the questions that you're kind of getting at is also the difference between, should companies be actively monitoring all use of their service versus what currently happens, which is content gets flagged or reported in some way to the company, and then they review and apply their terms of service. And I mean, even just starting with issues of scale, it is basic. I forget what the current stat is for YouTube. Something like 400 hours of video are uploaded to YouTube every minute. It's just something absurd, where it very clearly is, you can realize that there is no way for the company to pre-screen or to actively review every single bit of content that it is hosting on somebody else's behalf. So I think that's one of the first sticking points that you run into when you're trying to think, oh, is there more of this kind of active monitoring and enforcement that companies could do? If they were legally required to do that, that would kind of undermine the whole sort of basis for there being companies willing to host user-generated content around the web. But just on the Apple versus FBI case, I think that's an excellent case for exactly this question you're asking of, where's the limit? And you're sort of seeing this, including in having the hearing get postponed. Everybody's looking for a way short of what the FBI is asking for law enforcement to get that data. Is it stored on iCloud? Is there some other way we can get it off the phone? Is there something short of the government compelling Apple to write new software and sign its name to it that it's trustworthy when Apple believes the exact opposite? Is there something short of that? Because as the dozens of human rights groups that filed briefs in support of Apple and all of the tech companies that filed briefs in support of Apple in this case are saying, we think that what the FBI is asking is a step too far. But that doesn't mean that there are not many, many other things far short of that fall under, very kind of standard law enforcement interaction with companies, using warrants, court processes, and all of that.
So we're at the last question. So I'm going to give the gentleman in the second row one more shot at the panel, and then we're going to.
Let me try to rephrase your question. You were asking about Gmail. That is the ad robots. Read each message to say, oh, this person is shopping for a washer and dryer or an AK-47 or whatever. So is there some system where if somebody starts using every ISIS keyword in the book, then that gets flagged? Or do you show ads for, hey, here's an imam you should listen to instead?
No, it's okay. So I think what's most useful for me is really just to sort of pivot back to our general approach to what we're doing, especially on YouTube, which is about counter speech. And, we comply with law enforcement. And as Emma, all the things that Emma raised are things that we're doing all the time. But when it comes to the fact that there are messages out there in the world that are unhelpful, having an open platform where there are people who can express different views is the best way to affect that change. And so for us, that's where we're putting a lot of stock.
And that'll be the last word in our own open platform. Thank you to the panelists for a wonderful discussion, and thank you to the audience for good participation, to Susan and for GW for hosting us. Thank you all very much.
And we have another event coming up in April on human rights and internet, which we need to plan.
Good.
Thank you, everybody, for coming.
Get to say my answer, just echoing Jason's point of view. He's making mistakes.
Sure. I hope that was what you were looking for.